Real estate license exams for dummies. Part 3 is all minds. Owning and transferring real estate. Chapter 10. Giving up or losing property. Question and answers. The language of involuntary loss of property is pretty universal, in general, from one state to the next, but the specific requirements may not be. For example, all states acknowledge the concept of an adverse possession or claiming a right of title to someone else's property because of continuous use, but each state uses different time frames for it to take effect. The review question in this section focuses on the more general knowledge that is applicable in every state. So you need to check out the details in your own state before taking an exam. Question number 1. The law governing how heirs inherit property when a deceased has no will is called the law of A. Descent, B. Devise, C. Decibate, B. Escheats. Correct answer, A. Descent. You may have wanted to choose escheats. Remember, escheats applies only when the deceased dies with no will and no heirs. Devise a real property that is inheritance, and a testate is when someone dies with the will. Question number 2. By which of the following can you not lose title to your property involuntarily? A. Adverse possession, B. Foreclosure, C. Dedication, D. Efusion. Correct answer is C. Dedication. Dedication is voluntarily giving property to the government. The other answers are ways of losing your property involuntarily. You can brush up on those methods by reviewing by force, losing property involuntarily early in this chapter. Be careful of the questions like this that have a double negative. You might try to reinstate the question yourself, eliminating one of the negatives. In this case, by which of the following can you lose your title to your property involuntarily? Whichever answer fits the statement that are all the answers wrong. Question number 3. Mary crosses Joe's property for a number of years as she drives into her driveway. Mary sells to Alice, who continues to do the same thing. Alice sells to Barbara, who does it for a few more years, and finally claims the right to do so by adverse possession. Barbara may have accumulated enough years to claim adverse possession by the concept A. Excretion, B. Encroachment, C. Notorious use, D. Tacking. Correct answer is D. Tacking. Notorious use is one of the requirements for claiming adverse possession, but the accumulation of the required period of use by successive people is called tacking. Excretion is adding soil to your land by nature's natural actions. Encroachment is the unauthorized or illegal use of someone's property by another person. See Chapter 8. Question number 4. Joe and Sam jointly own an apartment building. They can't agree on anything, including how to dissolve their partnership. Joe finally files a suit for A. Efusion, B. Eviction, C. Escheats, D. Partition. Correct answer is D. Partitions. Partitions is a court action to divide a single property that is owned by two or more people in shares. Efusion is loss of land caused by a sudden act of nature, like an earthquake. Eviction is the action of a landlord to remove a tenant. See Chapter 12. Escheats is when the state gets the property because you die without a will and without heirs. Question number 5. The process by which a will is validated is called A. Surrogacy, B. Execution, C. validation, D, probate. Correct answer is D, probate. Surrogacy may confuse you because probate takes place in surrogate courts. Validation is, of course, the real word, but has no meaning in this context. Execution as a real estate term usually refers to the signing a document like a contract. Question number 6. Subdivide some land for a residential development. You want to give the streets to the town. You do so by A, descent, B, dedication, C, effusion, D, divestiture. Correct answer is B, dedication. Dedication is giving land voluntarily to the government. Descent refers to the laws of inheritance. Effusion is a sudden loss of land caused by natural processes. Divestiture is a general business term, meaning to get rid of some land. Question number 7. The right of a city to take private property for public use is called A, foreclosure, D, dedication, C, eminent domain, D, escheats. Correct answer is C, eminent domain. Eminent domain is the right of a municipality to take property against the wishes of the owner. Dedication is when the person voluntarily gives property to the municipality. Foreclosure is when a bank or municipality takes the property for non-payment of a mortgage or taxes, respectively. Escheats is when the state gets your property because you died without a will or without heirs. Question number 8. The person whom a will is prepared is known as A, a grantor, B, administrator, C, the executor, D, the testator. Correct answer is testator, related to the word testate, which means to die with a will. A grantor is a living person who conveys property to another. An administrator usually is appointed by the courts to handle someone's property, as in the case of someone who may be declared mentally incompetent. An executor is appointed by the courts to handle someone's estate after he dies. Question number 9. The gradual wearing away of land by the forces of nature is called effusion. A, effusion, B, excretion, C, erosion, D, effusion. Correct answer is erosion. Effusion almost is the same thing as erosion, only it's a sudden loss of land, not a gradual one. Excretion and effusion have to do with the accumulation of soil or by sand by natural forces like rivers. Question number 10. Harry has a new grandson a year after he writes his will and wants to leave him a special gift. To make this change to the will, he must likely execute A, a new will, B, codicil, C, divestment, or D, descent. Correct answer is B, codicil. There's a fine point here. Harry could execute a new will, but clearly the change to the existing will is a small one, which is exactly what the codicil is for. Divestments is related to devise, which is the real property left to someone in a will. Laws of descent govern how property is distributed to the heirs when there is no will. And that was part 3. It's all minds, owning and transferring real estate. Chapter 10, giving up or losing property. Review questions and answers. Thank you.